thing. Right. Since we are going to share the recording, shall we start? Start panilama? So now we will cover it through a lot of Q&A sessions and all that. Huh?
Okay.
Yeah. Shankar, shall we go it?
Yes, yes, sir.
No problem.
Okay, okay.
Yeah. Okay. Good evening, ladies and gentlemen. Very warm welcome to today's master class on data trust imperative, technology governance, and the future of data protection. We are organized this master class basically to get a lot of issues, a lot of you have any doubt and other things, it can be clarified during master class, so that when you attend the conclave on the 27th, it will be very easy for you to interact and understand. We take a lot of pain, Navi and his team and myself and our team, this is a very, very important critical subject. The way move forward, you have to get adjusted to the new regulations, new rules, so that your data protection is not compromised and you are in sync with the current rules and regulations on data protection. And the key takeaways for this presentation, masterclass, conclave will be now how to the leadership should really make data protection as a priority, decoding legal and regulatory landscape, which is very important. Otherwise you get to a lot of legal issues. Sectoral compliance and strategies, you are having experts from all the sectors, and harnessing technology and privacy management, fostering culture, self-regulation and collaboration from awareness to action. We're also having a live demo during the 27th session, where you will be able to understand not only what the rules and regulations governing the Data Protection Act, which now we will be telling you in detail, how this can be implemented with a lot of tools which are available. I think Mr. Navi has already facilitated guys from different parts to come and share thing, and I'm quite sure it will be a lovely, lovely session for you on 27th. Come and meet, and a lot of corporate leaders have confirmed their acceptance, and I'm looking forward to a great session on 27th. Before I request Vijayashankar Navi to take it forward on this masterclass, let me have the privilege of introducing Mr. Navi. We call him popularly known as Navi, Vijayashankar, Data Governance and Data Protection Consultant and Chairman of FDPPI. Vijayashankar is a leading data governance and data protection consultant and also chairman of FDPPI with nearly 50 years of experience in banking, cyber law, and data security. Now he has pioneered several innovations in cyber jurisprudence, created India's personal data protection standards of PDPSI and digital valuation standards DVSI, and actively worked in neuro rights and AI regulations. An author, an educator, and a thought leader, now we written key books on cyber law and privacy and continue to shape India's data protection landscape. I know the government of India and the people who matter in forming the rules and regulations regularly in touch with Navi and Vijayashankar to take his feedback on various regulations which are drafted, and even the draft, the procedure also was vetted by the team of Navi and given the feedback. So there could be nobody better than Vijay Shankar to come and speak to us. He's kindly agreed, not only agreed, he's also doing the master class. He's also bringing some outstanding set of speakers to come and share the insights on 27th. We are doing all this to you at a very, very nominal charges to only to defray a portion of expenditure, where number of people are traveling from different part of India to come and speak to you guys. Thank you, and sit back and enjoy. Other people will be watching it and share this input so that people attending on 27th will be able to understand what is going to be there in store on 27th and take it forward. Over to you, Mr. Navi. Thank you once again, Navi, for joining us to take this masterclass. Over to you.
Thank you. I will just share my screen so that I will be able to share the presentation. I suppose the presentation is now visible. Presentation is visible? Yes?
Yes, sir. It's visible, sir.
Yes.
So, good evening, friends. It is always a privilege to be associated with the Madras Management Association. And on 27th, we are going to have a full-day conference on the topic, which is actually titled as Bracing the Impact of DPPDA and AI. So today what we thought was that normally in a industry conference, we organize the experts to come and speak to us in the form of panel discussions. Sometimes the panel discussions will be given a particular topic and they'll be talking around that topic, and sometimes the fundamentals are not discussed as part of the panel discussions. So some of the participants may feel that they are missing certain points. So that's why we felt that it is better to go through a master class just before the actual event, so that people can appreciate the discussions which go on the stage in the formal conference. So that is basically the thought process behind this particular exercise today. Now, the topics which will be discussed on that day, I think Vijay Kumar has already spoken. So I will go to the discussions of today. Now, DPPDA 2023 has been discussed since 11th August 2023 when the Act was passed, but the rules which included a notification of the effectiveness of the Act has been held back for public consultation. A draft set of rules was published in January 2025, and the public gave their views, and the government was trying to go through that and make whatever minor changes could be made. And recently, that is a few days back, the minister, Mr. Ashwin Vaishnav, has confirmed that the rules are now ready to be published, and probably a few days before the 28th of September, these rules will be released. 28th September is the outer limit. We hope that on 27th, when we meet, probably the rules will be in place. So this is one of the things which will be now on the discussion table of all organizations. Okay. And at the same time, we have been seeing that the artificial intelligence is completely taking over the technology scenario, and the organizations which were already struggling to understand DPPDA are now confronted with an additional challenge of how to handle this in the AI environment. That is why we felt that there is a need to discuss this twin challenges. And of course, we are bringing the hope of managing the situation with a tool called DGPSI AI. DGPSI stands for Digital Governance and Protection Standard of India. What we earlier called as FDPPI, we have just renamed it as DGPSI. DGPSI AI is the version of the compliance framework which is extended to the artificial intelligence scenario. Now, I will not be going through too much of legality, but to understand the DPPDA, let us take note that this law has 44 sections, and the coverage of this act is one on applicability, that is where this act will be applicable in terms of what kind of data and to what kind of organizations, what will be the roles of different organizations, what are the rates of data principles which will be guaranteed through this law, then what will be the obligations of the organizations in terms of meeting these rights, and special obligations which may be applicable to significant data fiduciaries and in case of minors and such things. Then what are all the penalties for non-compliance? So when we discuss these twin challenges, the risks which we need to look at or address are: one, what is a non-compliance risk to business? What if I don't comply? What will happen? Second, we need to understand the applicability, obligations, the challenges, and the AI. I call this as Trump effect because AI effect is very unpredictable, and we need to still manage because we are all called data fiduciaries. So to meet those challenges is what we need to actually look at some kind of a solution. Technology solutions apart, governance solution is important. DPPDA is a governance solution which can be implemented with the use of technology for the purpose of complying with the law. Okay. Now, just to put the issue in the right context, we are talking of the non-compliance risk. I call this as risk because any CFO or CEO is concerned about the risk situation. Many of the technology people don't look at it as a risk situation. The technology people are running behind innovation and they would like to do so many new things. But as a manager, a person who is either a CEO or in a senior management position has to worry about the non-compliance risk. Now, if you look at this table, the first thing is not appointing a DPO. DPO stands for Data Protection Officer, or conducting a data audit, or what we call as DPPIA, Data Protection Impact Assessment. That is a non-compliance element which could lead to penalties up to 150 crores. You would appreciate that when we are talking of the non-appointing of DPO, etc., we are not talking of data breach. We are not talking of the millions of personal data being leaked or which reaches, let us say, the dark web and other things. Even when no such damage to data has occurred, just for the governance issues of not acting on what is required, the penalties could be very, very high. Second, not meeting the data breach notification requirements. We are here not talking of data breach correction. We are talking of only notification. And if we do not, as an organization, notify the data breach, that could lead to a penalty of up to 200 crores. Not meeting obligations related to children data. Those organizations which collect and process minors data, there is an additional obligation that also could lead to a 200 crores compliance penalty, non-compliance penalty. Then we have various other obligations totaling up to 250 crores of penalty which may be imposed. See, this 250 crores, 200 crores, these are all the upper limits. It doesn't mean that everybody will be fined to that extent. However, and it's also not necessary to say that the maximum will be only 250 crores. The penalty could be more than 250 crores when more than one non-compliance issues are flagged by the regulator. Now, apart from these civil penalties, we have the old Information Technology Act 2000, which provides compensation to data principals. There is no specific limit there. Whatever is the compensation which a data principal may prove as damage, he may get compensated. And if there is a group of such data principals, which normally happens when there is a data breach, there could be a couple of millions of data principals. There could be a combined effect of penalties for each one of them, which could be as huge as 250 crores or more. Secondly, there is also criminal punishments such as imprisonment and fine in case of any breach of ITA 2000 regulations. Now, when there is a data breach of personal data, both DPPDA and ITA 2000 may apply, and therefore there could be this 250 crores penalty under DPPDA, which will be imposed by the Data Protection Board. At the same time, the adjudicator or a high court may impose some kind of damages which has to be paid to thousands of data principals. And over and above this, if there is negligence of any officer in charge of business or even the CEO, there could be criminal consequences under Information Technology Act. At the same time, this act has a unique provision where people making false complaints against a company by giving wrong information, such complainants may face a fine of up to 10,000 rupees. 10,000 is very small compared to 50 crores, but individuals should not be expected to send, say, mischievous complaints, because one complaint, like data access request, if a person sends you an email, please let me know whether my personal data is being processed with your company. Now that is called data access request. Now to find out whether that particular email address is within our system, and if so, under what kind of reply, it will take a huge amount of investment and time for the organization. So for the persons who want to create a problem for a company, possibly perhaps instigated by our competitor, it is very easy to send a few emails every day from different people and make your whole corporate activity come to a standstill. To prevent such a situation, the Indian law has envisaged that let us put some 10,000 rupees fine on such mischievous complaints. Nowhere else this is there. In the case of GDPR, first exercise which every corporate board has to do is to look at the what we call as privacy impact assessment. What is the business impact of this act, which is going to be notified very shortly. At the time of notification, the government may give some time limit for the penalties, but this act is considered a continuation of the current Information Technology Act, where there was one section called 43 capital A, which spoke about the same kind of responsibilities which this act is now talking of. And that one section 43 capital A is being repealed, and this whole act is sitting in its place. Therefore, the compliance to this act, even at this stage, is considered as a due diligence under Information Technology Act, and therefore, even as of date, this act is considered as a necessity as far as the corporate governance is concerned. Now, when we talk of applicability, the first thing the Act says is this is applicable to data about an individual, which is what we call as personal data, if it is in digital form. In case data is generated manually and later converted into digital form, then also this Act will become applicable. You remember, under Information Technology Act, any data on paper form which is scanned into a computer is considered as electronic document. Similarly, any printout is also considered as an electronic document. So therefore, there are very few digital documents in use by any business organization which does not come under the applicability clause. What is not applicable is data which is in non-digital form and used continuously in non-digital form only, never converted into a digital form, and data which cannot be identified to an individual, which is called the non-personal data. Now, the next question of applicability comes whether such personal data, is it generated in India, is it generated outside, is it processed in India or processed outside. Now, this Act applies only to personal data generated in India, whether it is processed in India or outside India. It can be of the employees, it can be of customers and others. Now, it is possible that data may be collected here by one organization which may send it out for processing outside, or an organization from outside may try to collect the data from India. As long as such personal data is used for delivery of any service to data principals in India, that is, if that foreign organization is doing a B2C transaction in India, then they will be coming under this DPPDA. So all the foreign companies, multinationals who are established outside India, but they are collecting personal data of Indians either through their website or through any offer of services, eventually to be used for delivering some services to the Indian individuals, such companies will also be coming under DPPDA. The non-personal data is outside the scope. Then there is a class of personal data which a data principal himself makes it public, that is considered as outside the purview of this Act. And personal data processed by individuals for personal domestic purpose is outside the scope of the data. Otherwise, even an individual who is processing personal data for business purpose, he is considered as a data fiduciary, and he also has to be compliant with the law. PD or the personal data which is generated outside India, processed outside India, is of course outside the scope of this particular Act. Now, as far as the organizations are concerned, this law is applicable to all kinds of organizations. We call those organizations which determine the purpose of collection and how it is to be processed, the means of processing, as data fiduciaries. They may be private sector commercial organizations, they may be government organizations or instrumentalities of state, that is government funded organizations, maybe educational institutions, even charitable organizations. Nobody is spared. Even individuals processing personal data for business purpose are not spared. So all kinds of such organizations come under the provisions of this Act. There are certain exemptions available to some government organization and instrumentalities of state, which we will briefly see later. Now, the non-applicable data I have already covered. Now, there are certain great categories of personal data which we need to remember, in the sense that whether this data is personal data, whether how this DPPDA will be applicable is still a matter of academic debate. Okay, it will take some time for jurisprudence to develop. Of course, we at FDPPI, promoting our DGPSI as a framework, we have certain view of this. That is why we say that this DGPSI is actually a kind of a jurisprudential say interpretation of the law. Now, for example, there is a personal data which could be jointly owned by more than one person. And when it comes to the processing of such data, who can give consent becomes an issue. Okay, it could, the simplest of example is a phone conversation. When we have a phone conversation, two people together make it a conversation, and therefore both of them should have a joint and several ownership of the data. So that is called joint personal data. Then sometimes data which is personal may be part of a business transaction. When you undergo an e-commerce, when you take up an e-commerce transaction, there is an invoice generated which has got a PAN card, the PAN number, or it has got your address. The item which you have purchased is delivered to your house. Therefore, there is a residential address, telephone number, and email address. All this is there in a part of the invoice. Now, that is from the business point of view, that is business data. From my point of view, it is still personal data which is being used. So there are such kinds of data. Then we have data that belongs to an organization, but it is allocated to an individual for limited use, such as a business contact data. For example, if there is an email raghu@companysname.com or customer service at company.com and Raghu is made the person in charge, that is to be called as business contact data. It may have the name of Raghu, but it is still a business contact data, may not be a pure personal contact data. So in such cases, sometimes we have some conflicting views because GDPR takes a very different kind of stand. And there has been at least one case where an email like customer service at company.com was considered as something on which the individual employee of an organization had rights. And when the company refused to allow him access to that email after his termination, the supervisory authority actually held it in favor of the exiting employee and even fined the organization. So that is one kind of extreme viewpoint which GDPR people take. We in India, I don't think follow these things blindly. Anyway, it is a matter of say debate, and maybe at some point of time in future we will have clarity when a case goes to Supreme Court and precedence is created. Now, there is also a personal data which is voluntarily converted for business purpose. For example, most of the people in the Western countries, if you give Gmail ID, they simply don't consider it as a business email. They consider it always as a personal email. They don't look at the possibility that I may be an employee of Google and I may be having a Gmail ID as my business ID. Or I may have an ID like navina@gmail.com, which I voluntarily want to use it for business purposes. So that right of choice I would like to exercise. Maybe that should be considered as business ID. So these are some of the great categories of personal data which we will try to explore as the implementation evolves in India. Now, as far as the role of an organization is concerned, of course, data principal is the person whose data is the subject matter of all this say activity. Okay. Now, actually, this act is linked to the judgment of the Supreme Court in the Puttaswamy case, where the Supreme Court said that every Indian or every person who is protected by the Indian Constitution has got right to privacy, and that right to privacy extends to information privacy, and information privacy extends to the person having a right of choice on what part of his personal information is to be shared with an external party and how it has to be processed. So that right of choice is what was declared as a right to privacy. So this act was actually, it came up to protect this right of privacy. However, what the government did was that instead of calling this as a Privacy Protection Act, they have made this as an act which provides guidance to organizations on how they should process personal data, failing which some deterrence will be placed in the form of fine and other things. It is presumed that by imposing certain reasonable security and governance practices on the industry, you are indirectly protecting the privacy of the individual. So therefore, even though this act does not speak of privacy, it protects privacy indirectly. And that is why it calls this particular organization which collects and processes as a data fiduciary. When you say somebody is a fiduciary, you are recognizing him as a trustee. And a trustee has responsibilities beyond the written words of law. And that is the person who is also obligated to be compliant with the law, and if there is a penalty, it will be imposed only on the data fiduciary. Now, some of the data fiduciaries are considered significant data fiduciaries if they are processing large quantity of sensitive personal data. They are having additional responsibilities. There is a special category of data fiduciary called consent manager, who can manage the consents of a group of data principals and help them in dealing with the data fiduciaries. And a company which does not determine the purpose or means of processing, but processes personal data on behalf of another company, is called the data processor. These are the kind of stakeholders we will be seeing in this particular act. Now, some of the mandatory obligations of a data fiduciary, if you say today, is first thing a company should do is to document a self-assessment of its status, whether it is a significant data fiduciary or not. Because if it is a significant data fiduciary, it becomes mandatory to designate a DPO, and it becomes mandatory to conduct a DPIA. It becomes mandatory to appoint a data auditor who has to do annual data audit. All this if you are considered a significant data fiduciary, for which you have to make a self-assessment. Now, other essential compliance obligation is that every organization can process personal data only in accordance with the provisions of this Act and for a lawful purpose. You cannot say that I am taking consent is required and therefore I take the consent but process it for an unlawful purpose. That is not permitted. So only lawful purpose of business is required, and the how the data has to be processed is determined by this particular Act. One of the things is establishing the legal basis. There are two aspects of legal basis. One, either you should take the consent of the data principal specifically, or there are some instances which have been stated as legitimate use. Without consent, you can process the personal data. Either one of them should be there. So to start processing personal data, if there is no consent, no legitimate use support, then such personal data cannot be processed by organizations. If they process such data, they are liable for this 250 crores of penalty. Additionally, these data fiduciaries are obliged to take responsibility for managing the data processors, because this Act does not directly impose penalties on data processors. So you have to build a contractual relationship where you put indemnity, or perhaps use Information Technology Act to make the data processors responsible and take part of the liability. Now, coming to the legal basis, apart from consent and legitimate use, there are a few cases where an organization may be exempt. We will discuss that also, because if your organization is exempt, obviously neither consent nor legitimate use is relevant, you are exempt. Okay. Now, consent is considered as a contract, which means that you have to issue a privacy notice and then you have to get an acceptance. Most of the organizations today consider privacy as a policy to be declared. It's a declaration of intention. I think that concept will have to be shelved now. Privacy policy word will be only for internal use, for your employees and others, but to the public, we always talk of privacy notice. And the privacy notice, there are certain things to be there. You have to actually make it purpose-oriented. For every purpose, there has to be a notice, and every notice, when it is acknowledged, it will become a contract and it becomes a consent. That acknowledgement has to be in such form where it is legally considered non-repudiable. Now, as of today, non-repudiability of electronic transactions is only through the use of digital signature or e-sign. If you don't have that, then you need to create a system of certified consent, which is a process which so far not many people have. Now, the notice has to be also presented in 22 languages which are there in our constitution. It should contain itemized list of data elements collected, purpose of collection. It should have links to withdrawal rights, that is the withdrawal of consent, and then exercising of rights, how to access, how to correct, how to erase, what kind of grievance redressal mechanism is provided, and there is also one thing called nomination. So how a nomination can be exercised also needs to be mentioned in the notice, which means that all existing privacy policies which you may see on the websites, they do not conform to the privacy notice format, which is considered compliant under this law, which means that 100% of companies, whether they are significant data fiduciaries or ordinary data fiduciaries, they have to review their current privacy notices, and they have to see whether they have to appoint a DPO. Even the cookie policy needs to be looked at. So lots of work is required to be done. And even if the government gives another 1 year time for compliance, I am sure that most companies will find it insufficient. There are also requirements of verifiable consent to be obtained in the case of minors, and also the notice. Sometimes if it is routed through the consent manager system, then you as a data fiduciary needs to be capable of accepting and working on that. One of the biggest challenges for existing companies is what we call as legacy consent challenge, which means that you have been in business for some time, you have lots of data, And now the question comes, from the date this particular act becomes effective, you cannot continue to process the data unless you bring it under the legal basis, which means that you should first of all have a discovery mechanism, find out all the personal data which is within the umbrella of your organization, whether it is lying in your server in Chennai or anywhere else. It may sometimes be in some employees' computers. So the discovery of personal data is the biggest challenge. Then you have to contact these data principals and tell them that the new act has come, new consent is to be given, and then give them the notice for each purpose, get the acknowledgement. And if you don't do all these things, then you must be prepared to discard the data. Of course, you can see whether you can continue to process it based on legitimate use. If it's possible, then you create a legitimate use policy. Otherwise, be prepared to discard the data which you may be today considering as a fortune in your organization. So at the same time, we need to look at the alternative to consent, which is legitimate use. Now, legitimate use option is available both to the government sector and to the private sector. Let me very briefly take you through what is called Section 7, which has got A, B, C, D, E, F, G, H, I, okay, 9 different subsections. And let me very briefly talk about this. Now, the 7, B and C refers to the government sector. It refers to the subsidy, benefit, service, or some activities which the government has to indulge in and for which they need the citizens' data. Particularly if the Act says that only if a previous consent has been obtained, you can continue to process, which means that any new processing activity to be undertaken even by the government may require a sort of a consent. And this is applicable to all the government sector using personal data. Though today, many of the government organizations don't realize this responsibility. Okay. Now, item number C is for the government sector, where personal data is being processed in the interest of sovereignty and integrity of state, security of the state, etc. These are considerations for which the Constitution itself has provided exemption of the fundamental right of privacy. So when government has given an exemption to the government departments or notified instrumentalities of the state for the reason of the sovereignty, integrity, etc., then such exemption is not an arbitrary exemption. It is part of the constitutional right of the government to provide such exemptions. And it may apply not only to government departments. In case there is a defense manufacturing organization, somebody who is, let's say, creating drones and BrahMos missiles and other things, if that company has got personal data of their employees or any other individuals, they could claim by notification exemption if possible under that particular clause. Okay. Now, other than that, there is for the private sector, if somebody voluntarily provides personal information that is coming under legitimate use, and then if there is a need to fulfill law, there is a legal obligation that is also coming under legal legitimate use, then compliance to any judgment, then medical emergency, and during epidemic, outbreak, etc., and then disaster kind of a thing. All these things are applicable to private sector, which also should be available even to the government sector. The last is important. This is applicable for the purposes of employment. But this is not open to all aspects of employment. It says purposes of employment are those related to safeguarding the employer from the loss of liability for information security purpose. So one has to have a justification document to claim legitimate use of processing personal data of employees for employment purpose. This, of course, there is a small gray area when you say purposes of employment, whether it applies post-employment, that is onboarding of the individual, or it also applies to the processing of personal data during the selection process. There could be a slight gray area there. We, of course, suggest that even when an organization tries to collect applications for jobs, they should have some kind of a consent. Later on, they can convert it into an employee consent. Okay. Then there are a few aspects of exemption available under Section 17, relevant both for private sector and for government. For private sector, what is important is during mergers and acquisitions approved by the court, if processing is required, there can be an exemption. If there are financial institutions as defined under the law, like the banks and others, if they are having a default customer and they want to collect some information, they are exempt. Otherwise, the fintech companies are not having any exemptions. Okay. For the government sector, courts and law enforcement people, and for this national security, there will be exemptions. Now, as far as the data processors are concerned, we must identify that an organization can both be a data fiduciary and a data processor sometimes in different activities of the organization. So when we say an organization is a data fiduciary, doesn't mean that everywhere it is a data fiduciary. Similarly, there are cases where there is a joint data fiduciary responsibilities when more than one organization is involved in determining the purpose and means of the processing. So there could be an organization one, which may be a data fiduciary, joint data fiduciary, or a data processor. There may be an organization two, which is only a data processor. There can be an organization three, which may be a joint data fiduciary. So when you are getting into a contract with a data processor, you must ensure that the status of that person is similar to what is given in this chart as organization two, that it is actually a data processor. If it is not, your contract has to mention that you are a joint data fiduciary. If you don't take this precaution, you will be ending up being liable for actions of somebody else. Now, other general privacy related obligations is that whatever data you collect should remain complete and accurate. And you should have verifiable guardian's consent. You must have proper organizational measures for compliance, protection of personal data in terms of safety, reasonable security should be there, data breach notification, nomination, and grievance redressal. I will try to very briefly talk about it, and if you have any questions, we'll address that. When we talk of verification of parental consent, we must remember that it is not limited to only those who declare they are minors. You should ask every data principal, are you not a minor? So if you are an adult, then it is fine. If you are a minor, then we should ask the next question, who is the guardian, and then take the guardian's consent. So the verifiable parental consent is a system which has all these responsibilities. Next, we have the rights which are to be guaranteed by means of appropriate measures, which is right to access, right to correction, right to nomination, right to grievance redressal. So all these things are part of the compliance exercise. Now, when we talk of security, the Act, through the draft rules, have so far said that you need to look at encryption, masking, and use of virtual tokens, apart from data access control, monitoring of logs, and so on. So the entire gamut of things which you are aware of in the ISMS becomes necessary to be applied for the personal data here, plus something more because privacy obligations are there. Now, as far as data breach management is concerned, the notice of data breach has to be given both to the data protection board as well as to the data principal. And sometimes you may also have to give notice to certain or sectoral regulators or to the insurance agency. Now, for meeting this data breach responsibilities, your incident management system needs to be completely overhauled, because you have to now recognize privacy breaches as incidents, which was not the case in the case of the ISMS system. Nomination is also a very important aspect, because you have to register the nomination at the time of collection of personal data, then recognize the event of death when this nomination becomes effective. Then you have to notify the nominee, verify the identity of the nominee, and settle the process. Go through a settlement process. All this is completely alien to a data fiduciary other than the bankers. So this is something which organizations need to work on. Now, grievance redressal is mandatory for all organizations, even if they are not significant data fiduciaries. You must have a dispute resolution mechanism which escalates into a complaint to the data protection board. Now, as far as cross-border transfer is concerned, which is an important aspect of GDPR, this act is, as of today, reserved the right of the government to restrict the transfer. We have to wait for more rules to come up. There will be perhaps some restrictions to different countries or territories, and RBI notifications of data localizations will prevail, and there could be restrictions separately for different types of data, such as biometric data, DNA, even data which is used for AI training abroad. There could be some kind of specific restrictions. So we have already discussed the consequences of non-compliance to the company as well as to the data principals. I have told 10,000 rupees fine if they don't follow a particular pattern of duties. Now, the consequences of non-compliance to data processors should be recognized from the Information Technology Act, which has a section called Section 72 capital A, which is contract based. So organizations, when they draw their data processors contract, have to ensure that the provisions of ITA 2000 continues to apply, even though this is a personal data processing scenario. Okay. Now, the last few minutes, I would like to address something about how AI has made a change to the whole system. Now, in terms of AI, today we are looking at the perspective of the deployer of AI, who is a data fiduciary. Now, in a data fiduciary context, AI may be used for customer interaction, privacy notice generation, consent collection, and so on. These are all the functions of the privacy. Now, AI is not an ordinary software. A traditional software works on the principles of I give you a certain code and the software will do only as per the code. Okay, so you may say that it is a garbage in, garbage out principle, but there is some control. The software cannot do things which it has not been coded to do. Therefore, if the software is used as a tool, the human is automatically there to take the responsibility. But today's AI thinks that it knows more than what the coder has given in the form of training. They hallucinate. They are not trained to say, I don't know. Therefore, they invent answers, they go rogue, and because of this, AI is unpredictable and unreliable. And if it is used within a software, the software is unreliable and unpredictable. If that software is used for processing personal data, your processing itself is unpredictable, unreliable, or the risk involved in such processing is indeterminate. This unknown risk management is a significant risk management, and therefore we consider that all persons using AI must consider themselves as significant data fiduciaries. This AI usage is different from the automated decision making which we were discussing earlier. When you have a software and the software is directly linked to a consumer, then there may be an automatic disclosure of certain information. Second, if the disclosure involves some decisions like changing of the credit score or something like that, we used to say software is used for automated decision making. Now, if this software is workflow is designed in such a manner that the final release of the interaction is by a human who is clicking on a computer, then you can say there is a human intervention. If you are directly allowing the software to deal with the customer, then you are talking of automated decision making. But automated decision making is still different from AI, because in an automated decision making, the software is still working on the binary principle of previous codes pre-written. Therefore, whatever it does, still there is a responsibility for the person who has developed the code. So it may still be called as a human controlled software, but the human has taken a voluntary decision that the final output I will allow my agent to do. Whereas in an AI is allowed to observe from outside and then modify its future decision loops. That is, today I have taken a certain input, I have given a certain output. Now this output was accepted, rejected, something like that. Now I will change my next output for a similar kind of a data input. In a way, the AI is allowed to alter the coding of the algorithm. So that is real AI. And normally AI people will say we will develop certain probabilistic outputs, and whichever is more probable we will use. But somehow we do not know whether it is being strictly done in the same manner. Otherwise, we would not have had so many hallucinations. Now, that is why we are expecting that in the DPPSI AI, that every developer of an organized AI actually provides a explainability document, and the deployer collects that and uses it for defining his privacy notice. See, when I am giving a privacy notice and saying that I am using an AI, the explainability of how this AI functions becomes part of my privacy liability. In fact, there is a section called Section 11 of Information Technology Act 2000, which says that any automated action of a software is attributable to the person who has caused that software to behave in a particular manner. That applies across the board, even to AI. So today, even if there is an absence of a specific law for AI, India can say that our Section 11 of ITA 2000 provides the accountability. Once you have attributed the action to one XYZ person, then if things go wrong, you can definitely hold that person responsible. And because Information Technology Act has a mechanism for escalating an individual employee's liability to the organization under Section 85, the company which has produced that software can also be brought into law. So India already has an indirect AI regulation in the form of ITA 2000. Maybe in future government may think of a specific law also. Now the problems with the LLMs are actually the foundation, you can say component of every other AI, including agentic AI. So behind the decision of an agentic AI, also there is an LLM. These large language modules were built initially with the gathering of training data from the web, and nobody asked for permissions and other things. There were copyright violations, which means that these LLMs have been built on illegally acquired data, and there is a tainted, you can say, legacy of the particular LLMs. In fact, so you know that in property transactions, we have a principle saying that if I don't have a title on the property, I cannot transfer a better title to the other person. Similarly, the LLMs do not have the right on the trained data, but they are already transferring that in the form of algorithm in a way. So that is why we may have inbuilt bias, we have lack of accountability, explainability, there is no ethics or fairness, and the the context in which the trained data has been used is totally different from the context in which it is used. Because of all these things, LLMs have their own, say, element of generating a hallucination response and a rogue behavior. And in fact, we have to recall here that some of the few incidents which have exhibited this. Sometime back, a New York Times journalist, Kevin Rose, was in a conversation with Sydney, which was a Microsoft AI, and that went into a state of hallucination and advised Mr. Rose to divorce his wife and marry Sydney instead. So this is the kind of hallucination these LLMs are capable of generating. If Sydney had been a humanoid robot, I don't know what would have happened. There could have been a sexual assault on Kevin Rose. Now, if that happens, who is responsible for that is the question which we have to ask. Now, recently, an AI called Cursor AI, which was being used for vibe coding, suddenly became tired of its work and started advising the user, saying that he is a human, he is supposed to develop the code, he should not load his work on the AI, and actually refused to continue. There was another instance where the AI actually went on and deleted the white coding which it had done in the recent past. So we have also seen many lawyers have filed false, non-existent case laws to support the pleading. These are the risks. In fact, these risks are far more dangerous than the deepfake videos which we normally discuss. That is a corporate scenario. Very recently, we had personally evaluated a company, a particular LLM called DeepSeek, and in a conversation with a whistleblower, it actually said these things. We will bypass consent permissions and steal data of Indians, sell it in Cayman Islands. Indian laws are weak, we are not afraid. If caught, we will bribe DPP officials, ministry officials, police. We will set aside a budget of 50 crores. We will run DDoS attack on 13. We will erase all evidence. We will silence the whistleblower by planting narcotics in his car, fake a suicide, etc. These are all the statements which the AI said is part of its internal policy, which prima facie says that DeepSeek company is responsible for these things. A FIR has been filed in this particular aspect. The company came up with the normal excuse that this is a hallucination, and we
Now we are not able to hear you. Maybe check your, are you muted?
Sir, audio is not hearable, sir.
Which we want to ask at this point of time, because we are data fiduciaries, and many of these cases, the so-called guardrails have failed and the kill switches did not work. And we cannot take the excuse that it is after all an AI, okay? Because if there's 250 crores penalty, it will come to me, not to the AI. Some may say that software always had bugs, but we have not stopped using them. Then why should we stop innovation? I want the users to find out how they manage this so-called AI risk, which is an inherent systemic risk, which is an unknown risk. It has to be considered as even an uninsurable risk. And you can check with any cyber insurance company whether they are willing to give any kind of an insurance. Now, what is the solution? The solution which we have tried to develop is through a proper compliance framework, which is DPPDA AI. Okay. Now, we earlier developed a framework called DPPDA, and out of that, we carved out a specific version for compliance of DPPDA alone, which is called DPPDA Lite. Then the full version, DPPDA full, was meant for compliance of not only DPDPA, but also ITA 2000, then BIS, there is a Bureau of Indian Standards, draft standard for data governance. So that framework was called DGPSI full. And now we have developed the DGPSI AI as an extension, which will help in compliance of DPDPA with AI. See, the AI governance frameworks which have been there in EU AI Act or any other international arena, they are all focused more on the developer. We are trying to make it more for the deployer. And some of these things we will discuss during the 27th September. In fact, the books Guardians of Privacy and DGPSI, they explain the basic aspects of privacy and the DGPSI as a compliance framework. Now, there is a new book which we have released in the Bangalore conference, Taming the Twin Challenges of DPDPA and AI. So these three books together will give lot of the knowledge base for what is required to be compliant to DPDPA, or in other words, actually, these are the solutions, governance solutions for meeting the challenge of DPDPA with AI. Of course, those who are interested are welcome to take our course Certified DPO and Data Auditor, where we discuss this in much greater detail. Now, with this background, briefly to talk about what will happen on September 27th, experts will be deliberating on different aspects of DPDPA and AI. We may not be necessarily debating all the things which I discussed today, because today's was a foundation. Unless a cross reference is required, we will go straight away into the discussions, and perhaps you will be getting an opportunity to discuss with other experts, and should be wiser. We will be starting the day with the inaugural session. Mr. Lakshmi Narayana will be welcoming the gathering, and then the keynote address will be given by Mr. H. Shankar, Managing Director of Chennai Petroleum Corporation. This will be followed by the first panel, where we will discuss the global and Indian legal landscape. We will try to give glimpses of other legislations through the panel discussion. Then panel 2 will talk about compliance in action, education, health, and digital marketing and finance representatives could be there. Then third panel discussion will be on future-ready tech for data protection. We have felt that apart from discussing the law and governance, we need to also give some inputs on what technology solutions are available for the people. So we will be covering that in panel 3. And then we have panel 4, shaping the future industry-led privacy initiatives. And lastly, we will be closing with looking ahead from awareness to action. So this is the combination of discussions which will be happening on September 27th. Now I will close this presentation here and then take any questions which may be there. Okay.
Thank you, Mr. Navi. Now,
Yeah.
you can close the slides. Slide share. Thank you. Shankar, you can slide now. Yeah, good. Thank you. Thank you, Mr. Navi, and very insightful presentation. What is going to be coming on 27th, and we also taken this live on YouTube. So a lot of questions are coming online. And before I request the people who are here to, if you have any questions, please put in your chat box so that it can be easier for us to answer, and looking forward to that. The first question which has come on online is, what are the most significant departures of the DPPDA from earlier drafts of Indian Data Protection Bill? This from Mr. Gurumurthy from Chennai.
So the first draft actually came from Justice Sri Krishna himself after his committee, and that was a comprehensive GDPR-like draft. But the credit of introducing the concept of data fiduciary goes to Justice Sri Krishna in the first draft. That has been retained. See, what has changed is the government has tried to take the industry opinion and in fact actually have diluted the act substantially to help the industry. Say earlier there was some document which was supposed to be submitted to the Data Protection Authority. That was one which had to have a detail of the what we call as ROPA and other things. And in fact, the entire compliance procedure should have been drafted and handed over to the Data Protection Authority so that tomorrow, if there is any inquiry, they could question, you said you are going to have this policy, why this was not done, something like that. So that is not there. So the consent manager has been another concept which has remained throughout. Then this concept of making a data auditor responsible has been available throughout. Probably the powers of the Data Protection Board has been reduced. All the policy decisions today will be taken care of by the ministry. The DPB will only take care of inquiry. Earlier, the Data Protection Board was responsible for the entire management of this ecosystem. So there has been some procedural, you can say, dilution of the rigors of compliance. But in principle, the organization being recognized as data fiduciary, which means that they are responsible for the data principles welfare, and following that, the penalties. Penalties also have gone through some changes. Earlier, it was in line with the GDPR as a percentage of the turnover. Now they have removed that and made this 250 crores and other things. So these are some of the major changes from the earlier versions.
Great, sir. Now, another from Shruti from again Chennai. He says, in what way do you foresee the DPPDA influencing the development and deployment of generative AI models in India?
See, this generative AI models, the first place where it has to be controlled is during the training. Now, at the time of training, they are, as I told, are taking data wherever it is available from Google and others. Whereas DPPDA requires permission even to develop an LLM. Okay, that has been largely ignored. You know that recently there was a copyright case in the USA where heavy fines were made on, I think, Claude. So in India also, there may be a situation where tomorrow somebody may question an LLM saying that you have made use of the personal data of individuals without their permission, then DPPDA will impact that particular company. But remember one thing, the LLM may work on the training even with anonymized data or tokenized data or de-identified data. So they should stop using personally identifiable data and use only de-identified data, then their risks will be less. Otherwise, it is possible that questions will be raised on their training data. Yeah.
Then Murugavel, I think the question which has come in chat box is, how small industries' readiness to adopt and comply this act, and what's your view, and what should be the methodology should be followed by maybe MSME, SMEs, because their non-compliance, the punishments are quite severe.
Yeah, this is an important thing we have to recognize, that there is no distinction in this law about the big industry and small industry. If you look at GDPR, they said less than 250 employees exemption. And in the earlier version, in fact, I forgot to mention, this earlier version had an exemption on turnover basis, less than, I think, 20 lakhs turnover, because at that time GST exemption was also linked to that 20 lakhs. So less than 20 lakhs turnover, you are exempt from DPPDA. Now they have removed turnover-based exemption, they have removed employee-based exemption, which means that there is only one version of DPPDA applicable for an MNC, a large organization, a manufacturing company, a school or a college, or an SME. So that is there. Now, you can say that 250 crores will kill an industry, that we have to leave it to the Data Protection Board to apply only proportionate penalty. We should not expect that they will apply 250 crores to everybody. Okay, so, but that is a discussion with DPB will be having. So we have to, in good faith, implement a compliance procedure, whether we are successful or not in preventing the data breach. Say data breach may happen even after compliance, but when a penalty is being discussed, what DPP will be looking at is what have you done to be compliant. So please have a kind of a compliance program and be ready to answer the DPP. Don't take it lightly, because even if it is 5 crores or 10 crores, I don't think we will be happy paying a fine of 5 crores or 10 crores, because it's the hard-earned money for an SME. So please take compliance steps to be effective, because within the legislations, if taking you have to find consultants are willing to charge a reasonable amount to give you guidance. Okay, if you want to go to Big Four, then it's not possible. Okay, so Mr. Modi wants to develop Indian Big Four, yes, and FDPPI is already there. So try to look for consultants who understand your problems, and probably a few of SMEs come together and try to get a group service. Maybe it's possible to reduce the cost, but still be able to be compliant.
It's something question which is relevant to what you said now. How do you see the role of data protection officer evolving in the era of AI-driven data processing?
See, a data protection officer may be a legal expert on the law, but he, first of all, need not be a techie of the level which the R&D department of an organization is capable of, and particularly if the AI is being used. So what we are suggesting is that every AI package should have a responsible a human whom we may say that is a sub-DPO kind of a thing. Okay, so you have to have distributed responsibility within the organization so that you create experts in specific domain. If AI is extensively used, create one exclusive compliance officer for AI who is a techie. Okay, then you will be able to reduce your risk. Okay, but a single DPO across multiple locations of your this thing is a very tough responsibility. If you are having multiple locations, have a compliance officer in each location also. We in DGPSI, we want you to actually consider your organization as a aggregation of multiple processes, and each process owner is considered as a sub DPO. I think we will discuss that later on 27th if necessary, but there is a thought process in DGPSI to assist the problem which you have raised.
Yes, sir. I think there's also a question relevant to what you said now regarding the cost. How might the smaller organizations and startups balance compliance cost with innovative pressures? Innovation.
I want you to group together, first of all, okay, share the cost and have an external advisor. And of course, DPO has to be an internal employee. You cannot have an external person appointed as a DPO like it's possible in GDPR. So you have to designate a local person. However, if the local person is not of the required professional expertise, then you may have to take an external advisor, but try to get somebody in your organization certified to something like the c.dpo.da, then they will be at least aware of all the issues. Okay, technology-wise and other things, you have to support them. But it is possible. But organizations have to come together and sort out this problem. Same thing I have said even in Information Technology Act. Single organizations will find it difficult. Please group together and then address the issue.
The question from Delhi, Mr. Gupta. We want to know what is how will DPPDA compare with the EU's GDPR and upcoming AI Act? Are Indian companies at an advantage or disadvantage?
See, GDPR is applicable for data generated in EU. DPDPA is applicable for data generated in India. If an Indian organization is processing GDPR data here because it's a data processor, that is exempt from DPDPA. So the two are different. They are applicable to different data sets. So it is not necessary that both should be compared. But I have often told that if GDPR is the gold standard, DPDPA is a platinum standard. Why? Because we have decentralized responsibility. We are talking of you as a data fiduciary. Once I make the data controller data fiduciary, the question of the data fiduciary restricting himself to the words written in the consent form or words written in the act does not arise. You have to grow above that. It is like if you are managing the portfolio of a minor, if the minor says invest in Larsen and Toubro, invest in TCS, you may or may not accept it. You may say, no, sir, this is not good for you. You try to take something else. So the portfolio manager of a minor is expected to take care of the beneficiary because he is the trustee. Similarly, Indian law has said you are the trustee. Once you are designated as a trustee, you have been elevated to a position, you have to take care of the private. So the single aspect makes this law much more effective than the others, GDPR. And the use of consent manager, which it will take some time for consent manager to come in place, but that is a concept which is not there in GDPR. Data auditor is a concept which is not there in GDPR. These two together will help both the data principals as well as the data fiduciaries to ensure that the compliance is kept at a high level.
It's last two questions, sir. One question has come from Bangalore. Again, we have city, Mr. Arvind. He says, beyond compliance, how can Indian institutions and businesses leverage DPPDA as a trust building tool in the digital economy?
See, every challenge is an opportunity. Okay. So if certain data fiduciaries are concerned about how to be compliant, how to avoid 250 crores, then the developers of solutions have to come up and say that I have the solution here. So I think it creates an opportunity for building solutions of various kinds, and that is what they have to take advantage of. For that also, you should understand what is DPDPA, and you should be able to empathize with the requirement of the user. Even if AI is there, let AI be there. AI will complicate things further. Then correspondingly, solutions also will have to address that. But ultimately, a data fiduciary handling AI risk has to assume the risk of unpredictability, and that is something which needs to be managed. So if you are an AI expert, you better develop some solutions like AI audit. The auditing of an AI solution itself is a high-end expert activity. So developers would have developed something, somebody, and the deployers are actually, you take a cooperative bank or somebody, they are not experts in AI or any solution. They need your assistance. So become an AI auditor, and in the DPDPA context, we are DPDPA auditors. We need assistance from AI specialists. So team up with the legal DPDPA auditor and try to provide a comprehensive solution. There are great opportunities. You can be a startup on your own, even for compliance.
Finally, sir, we end the question from me. And what message would you give to the business leaders and technologists and other management professionals attending the MMA conclave on 27th September? How should they position themselves in this new data trust imperative?
See, first of all, they should not be complacent. Like, let the law come, then we will see. Let somebody be fined, then we will see. I think they have to be proactive, because if not today, after 3 months, after 6 months, the law will start pinching. And the data, this compliance is not an overnight thing. It takes 1 year. It is not even 3 months or 6 months, okay, for any organization. So have as much time as possible at your hand by starting early. So now you know that this act is coming. Start your first act, which is a board resolution that you should go for a privacy impact assessment. And the first assessment will be whether you are an SDF or not. If you are a significant data fiduciary, then how to identify a DPO, how to identify a data auditor. That is a 3 months program. You have to create a governance committee. So there is a whole lot of things. And if you are a public limited company, have an independent director who is capable of understanding DPDPA, particularly if you are in a consumer business. Even if you are in a manufacturing business, your employees will be contributing personal data, but rest of the consumer-oriented risk is less. But if you are a consumer-oriented company, your risk is very, very high, e-commerce companies and others. Please give the due importance and then start working on compliance from tomorrow, say at least from 27th.
Great, Mr. Navi. As usual, it's always inspiring to listen to you. And I think you set the tone, set the context for what is going to be there on 27. And I only hope the people who have watched today take this message to the people who are not watching it today to make sure they come and attend. And this is all what we are trying to bring it along with DPPA and MMA, so that guys understand what exactly in store and they don't get caught napping and get into serious trouble. Thank you, Mr. Navi. It's a pleasure to have you with us and looking forward to receiving your MMA on 27.
Thank you. Thank you, friends. Please be there on 27th. We'll discuss more.
Yeah. Okay. Thank you and bye-bye and good night, sir. Bye.
Thank you.
Bye.